Well, good morning, everyone. I'm going to go ahead and get started. I think there's a couple more people coming in, but we have a lot of information to cover, and I want to leave time for questions. Good morning. My name is Julie Doherty. I am the Director of the Human Research Protections Program here at the University of Maryland, Baltimore, which includes the Institutional Review Board. And today's topic for HRPO Grand Rounds is on upcoming changes to the federal regulations governing human subjects research. When we're done with this topic, I'll take questions, and then we're also going to cover briefly some changes to the clinicaltrials.gov regulations. Many of you have gotten some queries from our office about registration of clinical trials, and I'm just going to do a brief overview and the why and the what, and again, take questions from you all. So in terms of some of the most significant changes to the human subjects regulations, biggest one being, or one of the biggest, is the use of a single IRB for multi-site cooperative research. This is being required by both NIH and by the federal regulations. We'll go into more depth about that and the effective dates for the implementation of those regulations. The use of external IRBs, which is something we've been doing here at UMB for several years, but it's going to be expanded in scope. Continuing review of research is no longer going to be required under various circumstances, so that is a major change to the upcoming regulations, which will decrease regulatory burden for investigators. There's also significant changes to certain definitions, including definitions of human subjects, definitions of what a clinical trial is, research, identifiable biospecimens, identifiable private information, and the expansion of the categories of groups of individuals who are going to be considered vulnerable populations. There has also been a major expansion of the exemption categories, which means, again, decreasing regulatory burden. Research that would have been in the past approved under expedited categories by the IRB and be potentially subject to continuing review now will meet the exemption categories and be exempt from IRB review and therefore exempt from continuing review. In terms of informed consent, this is probably one of the major areas of significant change. There's going to be new language that's required in the informed consent, new elements of informed consent to increase clarity. This new concept of broad consent, which I'll go into in more detail related to exemption categories. There's going to be recruitment and screening waivers, which will allow for waivers of informed consent, being able to look at certain information so you can screen subjects for recruitment. Major changes to clinical trials consent forms, including the requirement now that the final version of the consent form be published on a publicly available website. The use of electronic consent, federal regulations will now allow it. We will be working with our partners here at University Council to make sure that that concept is allowable under Maryland law. So we'll be talking more about that. And then legally authorized representatives and who they are and what they're defined as has expanded. So in terms of single IRBs for multi-site cooperative research, NIH and the revised common rule are now compatible with the requirement for the use of a single IRB for multi-site cooperative research. The difference is the implementation date. NIH's implementation date is January of 2018, and the federal regulations is January of 2020. So we have a little bit more time for non-NIH funded research, but since we are an institution that does a lot of federally funded research, we're working on that, and I'll give you more information on that. That is going to enhance and streamline the IRB review process for multi-site research. It increases the standards and protections for human subjects. It increases efficiency and effectiveness, allows for a streamlining of the process. The investigator has a decreased burden, does not have to submit to multiple IRBs, and helps to eliminate redundancy. And for those of you that have had to deal with multiple IRBs at a time, you know exactly what I'm talking about. Again, the effective date changes. The NIH change was actually supposed to be next week. They came to their senses, I guess, and said, okay, we'll put it to the same time as the other effective changes for the common rule. And I'm going to give you more info on what we're doing here as an institution related to single IRBs. So what does it apply to in terms of the use of a single IRB? So it applies to U.S. institutions that are engaged in cooperative research for the portion of the research conducted in the U.S. So this is both for NIH and for the common rule. So cooperative research means more than one site. But it is not applicable when more than a single IRB review is required by law. So there could be some state laws or some other laws that would preempt this, including tribal law. So if research is being done on an Indian reservation, for example. It wouldn't be applicable when any federal department or agency supporting the research determines and documents that the use of a single IRB is not appropriate. Currently, I don't have any examples of that, but there could be different instances where a certain funder decides that a single IRB would not be appropriate. It might be classified research, Department of Defense research might be an example. If this research is being conducted in a foreign site, not required for a single IRB. And for certain types of awards out of NIH. So career development K awards are exempt. Institutional training awards and fellowship awards do not have to follow the single IRB requirement. So in terms of this concept of a single IRB, most of you in this room are familiar with our electronic system here at UMB. The system is currently not configured to operate as a single IRB for large multi-site trials. We are, as an institution, looking at several options and opportunities to reconfigure or add on to the system so that we can operate as a single IRB for multi-site trials. We're looking at many different options. No final decisions have been made. Right now, we do operate as a single IRB for some smaller trials, so we have some experience there. But again, with the larger trials, 15, 20, 25 sites, we don't have the experience. But we're looking to see what our options and opportunities are. What we have engaged in and signed on to is this concept of Smart IRB Exchange. It's actually Smart IRB Reliance Exchange. This is an IT platform that was supported out of Duke and Vanderbilt, out of their Trial Innovation Center. And in May of 2017, UMB signed a Reliance agreement, which allows institutions who want to engage in multi-site research to initiate the Reliance process on a study-by-study basis. It supports all types of research, regardless of funding. You initiate the IRB review for a study. You have access to expertise around the nation. You can track your IRB review status, track approved documentation, and track IRB approvals. What it is not the equivalent of Cicero. It is not an IRB system. It is a Reliance tracking system. So, for example, if UMB agrees to rely on Duke to be the IRB of record for a study, if Duke was going to be the single IRB, the IRB of record, the PI and the study team here would be submitting documents for IRB review and approval to the Duke IRB electronic system. And that would be the IRB process. So we became a partner in May of 2017. Actually, right now there's about 265 participating sites. It goes up pretty frequently, and it involves all of the 64 CTSA hubs. We're currently not a CTSA hub, but I think they're hoping to be. And that's the link there. In terms of current external reliance agreements that we have here, we have master agreements currently in place with the VA Central IRB, so we don't have to do it on a study-by-study basis. And we also have a master agreement with the NCI Central IRB. We have about 16 studies where we rely on the VA and about 55 or 60 where we rely on the NCI Central IRB for both pediatric and adult oncology protocols. We do execute other reliance agreements on a case-by-case basis. Currently, we have 175 studies in which UMB relies on another IRB to be the IRB of record. In terms of the use of an external IRB, one of the areas that we have run into some challenges is in using an external IRB. The IRB authorization agreements have expanded in scope. It used to be that the document was about 1 to 2 pages, and in some instances, institutions have developed forms that are upwards of 19 or 20 pages in length. So you can imagine what that's like in terms of trying to review that on a case-by-case basis. One of the other areas that we're running into some challenges is indemnification language, which other institutions want to put into their agreements, and UMB, as a state institution, doesn't want to enter in agreements where there is indemnification language, so we've run into some challenges there. And I don't have an answer for how those are going to work out, but we are working very closely with the University Council to address those issues. The other thing, a couple of other things to keep in mind with the use of external IRBs is that if another IRB is going to be the IRB of record and someone on the team, your study team, whether you as the investigator or a study team member, has a conflict of interest and has a management plan which has been developed and is required for your study. It's a document that's been vetted through University Council here and through the President's Office. It's actually signed by Dr. Perman. That conflict of interest management plan has to be reviewed by the other IRB, that is the IRB of record. In certain circumstances, that IRB may be more restrictive in terms of what would be included in a management plan. So what do I mean by that? So if the UMB management plan says you just have to disclose your conflict of interest to research participants in the consent form, the other institutional review board might say, no, in fact, you can't be the principal investigator on the study because we believe that your conflict is such that in order to manage it, you cannot be the principal investigator. So that's just something to keep in mind when you're potentially thinking about using an external IRB. Other things to keep in mind is that HIPAA may be managed locally, so we may be reviewing your proposal just locally for HIPAA, whereas the other IRB will be reviewing it for ethical review. They may not manage HIPAA. The other thing that I need to stress is that UMB is still responsible for ensuring that investigators and study staff are qualified and meet standards to conduct research. This is why when you are thinking about agreeing, or when you do want to rely on another IRB, number one, you still submit your a truncated application in Cicero. That application still goes through the departmental review process so that the department or entity on campus knows that the research is potentially going to be conducted here at UMB. You also are still required to make sure that you have completed your city training and your HIPAA training. And again, the other IRB may pose more requirements on you. It just depends in terms of training. UMB is the organization that's responsible for the safe and appropriate performance of the research. So what exactly does that mean? It means that even though another IRB is the IRB of record, your research could still be subject to auditing and monitoring locally by UMB compliance. Because as an organization, UMB is responsible for knowing what's going on locally. So that activity may still take place. A major change in the new proposed regulations, and let me step back one step here. So these regulations still haven't been, I will say, finalized. They're still under review. My understanding is they're still under review at the White House. So there's still the potential that they could be yanked or they could be revised again. I'm not sure what the chances of that are, but given the fact that they are very less burdensome on investigators and a lot of the changes make a lot of sense, they may just move forward as they're written. But there's always the chance that something may change. So we're up to the minute here in terms of, it's like CNN late breaking news. If I knew anything different, I'd tell you. Right now, they're still on track. So the continuing review regulations. So research that's approved by expedited review will no longer require continuing review. That's a large percentage of the research that we conduct here at UMB. Almost 70 to 75% of the research is conducted by expedited review here. Exempt research, I'll go into further detail about this, is going to require something called limited IRB review, which we're basically equating with expedited review. Continuing review will not be required for research in which interventions have been completed. If there's data analysis, which will include the analysis of identifiable private information or identifiable biospecimens, you can see that's a huge expansion of the continuing review. And if the research involves data from clinical care that's accessed as part of follow-up, again, will not require continuing review. Now, there's a provision within the regulation that says the IRB can still require continuing review if they deem that it's justified. But if the IRB does that, they have to document. So some examples in which the IRB may decide that continuing review is warranted is if your study's over-enrolled or there's been issues of noncompliance. So then you would still be subject to continuing review. So guidance, we're looking for specific guidance that we're hoping is going to be forthcoming from the oversight agencies, OHRP. We're looking at determining whether existing studies that fall under expedited review will be transitioned to the new rule or stay with the old rule. You can see where everyone can't just submit all their documents in January because we'd end up with, 1,000 protocols that want to flip to the new regulations. That doesn't make any sense, and it would require a lot of review and oversight. Thought process being it might be the protocol would be subject to one more continuing review, and then it would be done. So we would be able to review things, the IRB would be able to review things in a more thorough and appropriate manner. Again, so we'll be operating under two different sets of rules. Old studies, new studies. Definitions. This is a big expansion of the regulations. So under the new rule, there's a new definition of a human subject, an expansion of the definition. So this is the living individual about whom an investigator conducting research obtains information or biospecimens through intervention or interaction with the individual and uses, studies, or analyzes the information or biospecimens, or obtains, uses, studies, analyzes, or generates identifiable private information or identifiable biospecimens. So that's a huge change. So interventions now references biospecimens. Interaction means communication or interpersonal contact between the investigator or the subject. And the definition of a clinical trial has changed. This has also changed. This is harmonized with NIH, which is how we then get into the whole clinicaltrials.gov area. So the new definition of a clinical trial is a research study in which one or more human subjects are prospectively assigned to one or more interventions, which may include placebo or other control, to evaluate the effects of the interventions on biomedical or behavioral health-related outcomes. And I have a list of those outcomes in a minute. Other areas, these following areas here would not be considered research. So an investigator would submit to the IRB for a determination of not human subjects research. So scholarly and journalistic activities, oral histories, journalism, biography, literary criticisms, legal research, and historical scholarships. Some public health activities related to Zika. Examples would be Zika and influenza that are conducted, supported, requested, ordered, required, or authorized by a public health authority. And that's where the nuance is there, public health authority. It's not just an investigator who's thinking about doing that type of research. It has to be funded or supported, requested, ordered, or required by a public health agency. Most public health research conducted by academics would most likely be excluded from that category. And the intent is for governmental public health agencies. So during times of public health crises. Collections and analysis of information, biospecimens, or records by or for a criminal justice agency would be considered not human subjects research. And departments of intelligence, homeland security, defense, or other national security missions, activities related to national security operations would be considered not human subjects research. We don't do classified research here, so at least not yet. So in terms of vulnerable populations, pregnant women was removed from as a category particularly related to exemption categories. We'll go into that a little bit more. Still applies for the, multi-center trials being done in, influenza studies, those types of things. So this is more related to the exemption categories. Handicapped or mentally disabled persons have been replaced as a vulnerable population with individuals with impaired decision-making capacity. And it has also been added economically or educationally disadvantaged persons is now a federally defined vulnerable population. So that adds to the current categories of children, prisoners, and pregnant women. And there's also categories where prisoners or the use of prisoner data and information is going to be allowed within the exemption categories. In terms of the exemption categories, the areas within these definitions that are in italics are the part of the exemption category that has changed. There's only one category, I believe, that hasn't changed, and that's category number 6, which was the taste and food quality. All the other ones have undergone major revision, and there's 2 new categories. So exemption category 1 is research conducted in established or commonly accepted educational settings. This part is new. That specifically involves normal educational practices that are not likely to adversely impact students' opportunity to learn, required educational content, or the assessment of educators who provide instruction. This includes most research on regular and special education instructional strategies, and research on the effectiveness of or the comparison among instructional techniques, curricula, or classroom management methods. Category number 2 was revised. This is research that only includes interactions involving educational tests, survey procedures, interview procedures, or observation of public behavior if at least one of the following criteria are met. So Part A and Part B, information obtained is recorded by the investigator in such a manner, and any disclosure, the next one, were in the previous regulation. Major change to this is the information obtained is recorded by the investigator in such a manner that the identity of the human subject can readily be ascertained directly or through identifiers linked to the subjects. And an IRB requires or conducts a limited IRB review to make the determination required. So you can see how you can still have the link, but the IRB has to conduct a limited IRB review, which would be expedited review, and the exemption category, the exemption determination would be made. And therefore, it would not be subject to continuing review, which they're getting rid of anyways, but category number 3 is new. This is research involving benign behavioral interventions in conjunction with the collection of information from an adult. So it does not apply to pediatrics. From an adult subject through verbal or written responses, including data entry. So even if somebody's sitting here at the computer putting in data. Or AV recording if the subject prospectively agrees to the intervention and information collection and at least one of the following is met. The information obtained is recorded by the investigator in such a manner that the identity cannot be readily ascertained directly or through identifiers linked to the subjects. Any disclosure of the human subject's responses outside the research would not reasonably place the subjects at risk of criminal or civil liability or be damaging to the subject's financial standing, employability, educational advancement, or reputation, or the information obtained is recorded by the investigator in such a manner that the identity of the human subject can readily be ascertained, directly or through identifiers linked to the subjects, and an IRB conducts a limited IRB review to make the determination required. So you can have those links, and the IRB will conduct a limited IRB review. So what's a benign behavioral intervention? These are the examples that were in the common rule. They're interventions that are brief in duration, and you can see where there's some gray areas and where the interpretation is going to be evolving. They're harmless, they're painless, they're not physically invasive, they're not likely to have a significant adverse lasting impact on the subjects, and the investigator has no reason to think the subjects will find the interventions offensive or embarrassing, and it does include authorized deception research. So you can see where that it's going to be subject to and very subjective. Exempt category number 4 is brand new. This involves secondary research and the use of identifiable private information or identifiable biospecimens if at least one of the following criteria are met. The private information or identifiable biospecimens are publicly available, and information which may include information about the biospecimens is recorded by the investigator in such a manner that the identity of the human subject cannot readily be ascertained directly or through identifiers linked to the subjects. The investigator does not contact the subjects, and the investigator will not re-identify subjects. And I don't know exactly what publicly available means. Does that mean it comes from a company? It comes from, it's in a database somewhere, it's in a database at NIH, and you can say, send me some specimens, I want to do X research on it. So it's publicly available. It's secondary research. There's specimens that are already sitting somewhere. Exemption category 5. Is for research and demonstration projects conducted or supported by a federal department or agency. It has a very narrow application. And the guidance in the Federal Register basically says contact OHRP so you can get guidance about implementing this and using this exemption category. Exemption category 6, unchanged, food and taste quality. Exemption category 7 and 8, these are brand new and bring forth a concept called broad consent. So this is, again, the secondary use of identifiable private information or identifiable biospecimens, including storage or maintenance for such secondary research for which broad consent is required. If the concept of broad consent is not adopted, in other words, if it's not adopted on our campus, then this type of research would not go on. The plan is it will be adopted on this campus, and we will be implementing the use of broad consent. There are limitations to the applicability of the exemption categories related to subparts B, C, and D, prisoners, children, pregnant women. I didn't go into all those details here because we could talk for 6 hours about the granular details about all these changes. This is, a higher level review. In terms of consent, this is one of the more extensively modified sections. They've added regulations for the use of biospecimens, including specific requirements for language in consent documents. The consent template will be completely revised and will be available sometime later in the year. It's actually changed the formatting requirements for the consent document and the order in which information needs to be presented to subjects. It includes language that pertains to the informed consent process. So there'll also be a consent for this concept of broad consent, a new template for storage, maintenance, and secondary use of identifiable private information and identifiable biospecimens. One of the concepts that's been introduced in the new regulations is this concept of a reasonable person. Sounds like legal language to me. I'm not a lawyer, but it sounds legal to me. Subjects must be provided with the information that a, quote, reasonable person would want to have in order to make an informed decision. And subjects must be provided an opportunity to discuss that information. But again, what does reasonable mean? A reasonable person in a cancer center study might be different than a reasonable person in an infectious disease study versus an epidemiology study. So again, we're looking for more guidance and on that term. The consent process, when you're discussing studies with potential participants, the informed consent process must begin with a concise and focused presentation of the key information. So the key information is not the 35-page consent document. You have to have it's almost like an executive summary of the consent that has to be presented up front to the subject. That is most likely to assist a prospective subject in understanding the reasons why one might or might not want to participate in the research. It's almost like a short form from the FDA. The informed consent must be organized and presented in a way that facilitates comprehension. Again, we're looking for guidance on that. Written informed consent will not be, in instances, will not be required for obtaining screening data and specimens. So a waiver of informed consent for that can be requested by the investigator. Here's the other caveat. One consent form for each clinical trial must be posted on the federal website after the trial is closed. I'm not sure why they decided that it was after the trial was closed, unless they wanted the final version of the consent form. But you can see why somebody who's got a lot of time on their hands will be trolling websites to make sure that informed consent is being done appropriately, that consent documents are comprehensive and include all the elements. We don't know if this is going to be required by the lead PI on a study, and then it has to be posted on clinicaltrials.gov. We don't have final guidance on that yet. The elements of informed consent for broad consent have expanded. So these are going to be the new elements that are going to be required if you're doing research with identifiable biospecimens or identifiable private information. So you have to include the basic elements which already exist, which you're all familiar with, which include risks, benefits, confidentiality, voluntariness, commercial profit, whole genome sequencing, and contact information. Those are elements that have to be in the consent now. For broad consent, you're going to have to include a general description of the types of research that might be conducted on those specimens or information, description of the identifiable information in biospecimens that might be used in future research, the sharing and types of institutions or researchers that might conduct the research, so academic medical centers, and we'll share it with infectious disease individuals. The length of time the identifiable information or biospecimens will be stored or used. And I don't know if indefinitely is allowed. Requires a statement that subjects will not be informed of the purpose or details of subsequent research. Unless known that clinically relevant research results will under all circumstances be disclosed to subjects, this element requires a statement that research results may not be disclosed to subjects. So if you are doing research, secondary research on these biospecimens, and find out that this person has some genetic disease that they can pass down in future generations, you may not be required to tell them. Contact information about rights, storage, and use, and in the event of research-related harm, who are they going to contact? So if broad consent procedures are used, an IRB may not omit or alter any of the required elements. So it's all or none concept. And for identifiable data specimens, criteria for waiver includes research not practicable without identifiers. So some of the specifics we need to work out is if the concept of broad consent is implemented and you approach a subject and say, I'd like to use your identifiable private information and your biospecimens for future research, and they say no, our understanding is there has to be some tracking mechanism so that then another research group doesn't come along and ask a similar question, even though you might be asking for a different disease group. So we're going to be coming out with guidance on that once it becomes available. Documentation of consent, electronic signatures are now allowed for consent documentation, but a written copy must still be given to the person signing the consent form. So that doesn't absolve you of that requirement. We are seeking guidance from University Council about electronic consent and what's allowed under Maryland law. I mean, how do you know that the person who's signing the consent is the person who you think is enrolling in the study if you're in Maryland and they're in Pennsylvania and they're just signing a document? Is that true electronic consent? Or is it you have to have a username and password and generate an electronic signature? So again, we're looking for local guidance on that. Consent forms may be read to subjects. That wasn't in the federal regulations in the past. Short forms must follow the presentation format. Short forms are usually used in FDA-regulated research. They have to follow the format. There also has been a waiver of documentation of consent that has been added if subjects are from a distinct cultural group or community in which signing consent forms is not the norm. Usually in the past, this was subject of intense discussion at IRB meetings about whether or not a certain group should be required to sign consent documents. So a lot of times it's the thumbprint, could be an X mark. Now there can be waivers for that if it's not the cultural norm. The Department of Labor is a new signatory to the common rule, and the Department of Justice dropped off the list. Don't know why. Within the past couple of years, there had been a requirement for the use of neonatal blood spots, which was considered human subjects research. That's now changed. It's not human subjects research. There also was the requirement that the IRB review all grant applications, so investigators had to upload the 500-page grant into Cicero. IRB doesn't have to review it anymore, so we don't want to see them. Also built into the regulation was that the definitions of identifiable private information and identifiable biospecimens will be examined within 1 year and at least every 4 years thereafter. Given that almost any piece of information that is affiliated with a person can identify them, and how technology changes day to day, they've realized that they need to look at these definitions and make sure that they're appropriate. So, additional information. We're going to be working under old rules and newer rules as of January. January 19th is when the regulations go into effect. That happens to be a Friday. They picked Friday. I'm not sure why, but they picked Friday. What does that mean? It means that if you have a study that you submit today, and it's in Cicero, and it sits in departmental review for 7 months because your departmental reviewer doesn't sign it, and then come January 19th, it moves through the process, all the new rules apply. So you would have to go back and use the new template, et cetera, if you were obtaining consent. Anything that gets approved after January 19th is subject to the new rules and regulations. Currently, the FDA is not harmonized with these regulations. So for those of you that do FDA-regulated research, these aren't harmonized. So you'll be subject to the DHHS regulations. The FDA has changed some of the requirements on waiver of informed consent for minimal risk research. We'll be doing some more education on that. But overall, the Cures Act from December of 2016 had some statements in it that the FDA needed to harmonize to the extent possible with DHHS, so that should be forthcoming. We'll see. We don't know what the VA is going to do. They are signatory to the common rules, so they will accept the changes, but are they going to accept them in whole, in part? Are they going to have additional requirements? Are they not going to accept that there'll be no continuing review? Don't know. We also don't know what the other departments and agencies are going to do, in whole or in part. We're looking for future guidance from OHRP. Again, effective date is January 2018. We've already started incorporating the changes into Cicero. So when you think about studies that will no longer require continuing review, we don't need to set an expiration date. So we're working on changes there. We're working on changes related to the exemption categories. So we're working with the School of Medicine IT group on that. Obviously, we can't push the changes yet because we don't know if they've been accepted by the government yet. So we're doing all this work, and they could pull the plug at the 25th hour, but we'll see. Training and education sessions like this, we're going to have more in-depth sessions as the regulations are rolled out. We'll be doing more of these grand rounds October, November, December. We'll be modifying our standard operating procedures, etc. Any questions related to that? If you have a question, she's going to give you the microphone just because.
So, 2 quick questions.
Sure.
Make sure I understand. So, if we are currently drawing blood for screening purposes, for like hemoglobin levels and so on, are you saying that consent is no longer required to do that?
It would be a waiver of, you'd have to request a waiver of written documentation, is my interpretation of that. But what we don't want is an influx of everyone submitting their protocols to say, okay, now I don't want to obtain written informed consent for screening, because
yeah, we were just consenting a lot of people that ended up being not eligible, and then we just moved on, but they signed a consent form, and we spent 2 hours reviewing the consent form with them.
Exactly.
To draw that blood. Okay.
Exactly.
That's huge.
So, because if we say come January 19th, we can apply all the new regulations to all the research that's out there, obviously everyone would submit their protocols, and we'd be completely inundated. So we're going to roll them out And it may be that we're going to say, the new rules don't apply to research that's already been approved.
I see.
Or the new rules don't apply to research that's already approved until continuing review. That way we can stagger volume.
Okay, my second question has to do with the grant that we just received a notice of grant award for on Friday. And we're going to be a clinical site for a multi-site drug trial. So the PI is in St. Louis, and she really wants over the next 3 months for us to get our IRB in order. So should we be working with someone specifically in your office? You? Okay. To figure out what that's going to look like and how to get it so that maybe in January we're ready? Okay.
And St. Louis is going to be the IRB of record?
I actually don't know those.
Okay. Yes, it would be me, so just call me.
Thanks,
Yes.
Julie.
Sure.
So I have a question regarding the smart IRB. I'm trying to visualize how that's going to work, or what it looks like, rather. So let's just say it's Duke, and we submit everything to Duke. Is a smart IRB a platform where Duke can cross-talk with you to obtain oversight waivers, so we don't have to go through Cicero anymore and things like that, or?
Well, you'll still have to go through Cicero because that is the mechanism for departmental review. So you still have to submit the truncated application in Cicero because that is the way that the department or entity conducts scientific review of the protocol. It's also our tracking mechanism locally to know how many protocols we have where another IRB is the IRB of record. Smart IRB Reliance platform allows UMB, whether representatives from the institution like myself and staff members like yourselves, who will be given access. If you request access to Smart IRB Reliance, you will be given access to it. So you can see the documents. You can see what I'm doing. You can see what you need to do, and you can get communication from the other entity. And it's all tracked right in there. So no more needs to be done by email. It's all within this area, this platform. But again, it's not an IRB review system. It's a Reliance tracking system. Why they called it Smart IRB, I don't know. I don't know.
So we will still need to send the partially executed IAA through Cicero to you in order to get it back, and then so we'll
Yes,
still need
that's
to
how
do
we
that.
would do it, yes.
Okay.
And you'll probably have to put it in the Smart IRB system too.
Okay. All right.
There might be some double documenting, but very minimal.
Okay, great.
Or double, not
duplicative
documenting,
work.
but putting it in two different places, yes.
And then the other question is, so if the UMB IRB is not responsible for reviewing COIs for external IRB research or oversight research, do you have plans to amend the Cicero application when adding study staff in external IRB studies to remove that COI line? How should we answer that?
No, because that's the only way that the institution here knows whether or not somebody has a significant financial interest. So if they answer the question yes, our conflict of interest officer gets notified. And she has to make a decision based on PHS, state law, institutional policy about whether or not an individual has a conflict of interest. If she says no, then it's okay to proceed with UMB relying on another IRB of record. If someone does have a conflict of interest, then that information has to be relayed to that other IRB.
Okay, so we are reviewing it then.
We're reviewing it from the standpoint of the institution, but not the IRB.
I see. Okay, thank you.
Another question with the Smart IOB, would we only be starting that process if we were a coordinating site and then it would be up to us, or would someone else contact us and request something through the Smart IRB if they were the coordinating site?
Could be both. So if the UMB investigator is the lead PI, like on this grant that just got awarded, they're the lead PI, they either did one of two things. When they submitted the grant, they've put in what IRB they want to rely on, which they may not have done because it wasn't required back then. Or now that it's been awarded, they have to say, tell me what IRB you're going to agree on, tell me what the process is, and then we'll start releasing funds. So it could be you're the lead PI, you have to identify the site, the IRB, and then you have to communicate with all the other sites to say, you're submitting everything to X IRB. And here's how you're going to do it. So that's going to be a coordinating center function, is coordinating these other sites. The lead PI is going to be responsible for coordinating the other sites.
I guess to flip it around, if we were just one of the sites on a commercially sponsored study, would we do anything different then? If we're submitting a partially executed IAA and Cicero, would we do anything with Smart IRB?
It depends on what, if the IRB of record wants to use that mechanism.
So they would initiate in that
Correct.
case.
And
Thank you.
they would communicate with you. Because the other thing is that you're going to be relaying information, and you do anyways now in multi-site trials, about number of enrollees and all that information, so that the lead site can submit one continuing review.
Suppose you're working on a application with transnational partners, where the lead PI is in Great Britain and other institutions are in numerous European and South American countries and 3 or 4 in the United States. You were talking about the cooperative research. Does it have to be a U.S. We would be a U.S. institution engaged in obtaining some of the responses for a portion of the research conducted. Is that part of the cooperative research?
So since the study involves foreign sites, you would not be required to use a single IRB.
We don't have to submit an IRB for that. We have some kind of a collaborative.
Right. So you must have an agreement where another IRB is the IRB of record for certain studies. But if that's the case, UMB has to agree that that is okay. There should be some type of documentation that says, our institution has agreed that for the portion of the research that's being conducted, UMB has agreed to rely on another IRB.
So we're waiting to get that institution's IRB approved. They call it the ethics review.
Correct.
And assuming that it covers all of the things that we would cover, then you won't have problem approving it, but we put it through Cicero.
Correct. There's only 2 foreign IRBs that we have agreed to rely on thus far. One's in Mali, Africa, and the other one's in Nigeria.
And if it's about educators who provide instruction, then it might be exempt anyway.
Might be exempt, but the only way to get an exemption would be to submit it to the IRB here.
Thank you.
So if you have specific, just give me a call. I can walk you through it all.
So one more question, Julie, thank you. So if I'm understanding this correctly, once the common rule goes into effect in 2020,
For single IRB.
for single IRB, so even industry-funded research
Yep.
will be under that umbrella? Okay. So it won't matter.
So if you have, so NCI's already got it under control, VA's got it, but, if, I don't know, the other studies, if they're multi-site, which is more than 2 sites, you have to have 1 IRB.
So if GSK or Merck
Exactly.
or whoever.
So they have a study that's going on in 15 different sites. Whoever the lead PI is, they have to identify, or the sponsor does, to say, this is the IRB we're going to use.
Okay.
And all of you need to agree to rely on that IRB.
And if it's spanned out internationally and they have like 10 sites in the US and 10 in the UK, then just for those 10 in the US, they have to use a single IRB.
I think so. I don't know if it's. I think you could do one for one for domestic, and then the other IRBs could be. I believe that that's an interpretation. I need to get confirmation on that.
Okay, thank